or lose the property. Those are your only two options.
I'd like to see your legal authority for that statement.
You're looking at it.
Diane Colwell. Pearls, camel coat, clipboard, carried like a gavel. She'd arrived before I finished reading the seizure paperwork, which told me something. People who show up that fast aren't enforcing rules, they're managing a timeline. Behind her, a security guard was running chain through the front axle of my father's 1967 Ford tractor. 40 years on this land. The chain rang against cold metal like something final. I kept reading. Mr. Merritt, her voice dropped half a register. I don't think you understand what's happening here. She was right. She just had the wrong person. I turned to the signature block, then the incorporated entity name at the header. Ridgemont Community Standards Association. I'd never heard of it, and I knew this county. I'll need your charter documents, I said. Statutory basis for Emergency Preservation Authority. Registered agent name. The smile again. The particular smile of someone who has never once been asked that question. What you need to focus on is your situation. I looked at her the way you look at something when you're confirming what you already suspected. Okay, I said. Just that. Okay. She expected panic. She expected a man who'd just inherited a problem too large to fight. When she didn't get it, something shifted behind her eyes. Not doubt, not yet, just the faint sensation that this wasn't going the direction she'd planned. She didn't know what I did for a living. She didn't know what I'd spent 12 years learning to recognize. The document in my hands wasn't a violation notice. It was a case file, and she'd just handed it to me herself. If someone hands you the weapon they plan to use against you, and you recognize it before they do you say something, or do you let them keep talking? My father's name was Robert Merritt. He ran Merritt Orchards for 40 years, 38 acres of apple trees outside Asheville, North Carolina, planted on land his own father had cleared by hand. He sold from a roadside stand he'd built in 1987. Rough-cut lumber, a tin roof, a hand-painted sign that had faded to almost nothing by the time I was old enough to read it. Every farmer's market from here to Knoxville knew his name. Not because he was loud about it, because the apples were honest. Pancreatic cancer took him in October, fast and without negotiation, the way that disease prefers. I flew in from Chicago with 2 days' notice and made it in time to sit with him through the last night. We didn't talk much. There wasn't much left to say that hadn't already been said across 40 years of Sunday phone calls and the particular silence of men who show love through showing up. He left me the land, the equipment, and a debt load that looked manageable on paper until you read the fine print. I'd been back 3 weeks when Diane Colwell appeared in the driveway. In those 3 weeks, I'd done what I always do in a new situation. I'd learned the terrain, filed the probate paperwork, walked every acre, read every document in my father's office, including the ones in the back of the bottom drawer that he'd clearly never intended anyone to find. There were letters from an attorney I didn't recognize, from a property management company called Blue Ridge Solutions. Polite at first, then less so. Time-stamped over 18 months, starting well before my father's diagnosis. Someone had wanted this land for a long time. I'm not a farmer. I spent 12 years in a federal office building in Chicago staring at spreadsheets, wire transfer records, and shell company registrations until the patterns became a language I read as naturally as English. My hands know how to type case notes at 2 in the morning. They don't know how to drive a tractor, but I know what predatory paperwork looks like. I know the architecture of manufactured debt. I know how you build a violation portfolio that looks legitimate from a distance and falls apart the moment someone pulls the incorporation records. My father never pulled those records. He trusted that people who carried clipboards and spoke in official tones had the authority they claimed. I did not share that trust. Standing in his kitchen the morning after Diane left, I set her portfolio on the table next to the letters from the bottom drawer. I made coffee. I looked at both stacks for a long moment. The timestamps lined up in a way that wasn't accidental. I opened my laptop, not because I was panicking, because I recognized the shape of what I was looking at, and I wanted to be certain before I did anything at all. Outside, the apple trees stood bare against a gray December sky. 40 years of my father's life, row after row, patient and still. They'd been waiting through worse than this. There's a thing that happens to people when they get a badge and a federal authorization code for the first time. Some of them get quiet. They understand almost immediately the weight of what they're now allowed to do, and that understanding makes them careful, deliberate. They learn to treat the authority like a scalpel, not a hammer. Others get loud. They find out they can make a room go still just by saying 3 letters, and they start saying those 3 letters every chance they get. I've worked with both kinds. I know which ones I'd trust with a complex case and which ones I wouldn't trust with a parking dispute. My supervisor in Chicago, a 26-year veteran named Pat Hollis, said it to me on my 3rd week. The credential is a tool. It's not a personality. She said if she ever caught me using it to win an argument I could have won without it, she'd put me on administrative leave herself. I never forgot that. In 12 years of financial crimes work, I had opened federal inquiries into hedge funds, regional banks, 3 municipal governments, and 1 very surprised orthodontist in suburban Milwaukee who had been laundering money through a chain of pediatric dental clinics. I had done all of it quietly, methodically, and without announcing myself until the moment announcement was the only tool left. That was the principle. You don't deploy what you have until you know exactly what you're deploying it against. Which is why, standing in my father's kitchen with Diane Colwell's portfolio on the table, I didn't call my field office, didn't pull credentials, didn't make a single phone call that would signal to anyone that this situation was anything other than what it appeared. A grieving son, an inherited debt, a 72-hour deadline he probably couldn't meet. I wanted to see the whole structure first. Because here's what I've learned from a decade of watching people build financial fraud operations. The part they show you is never the dangerous part. The dangerous part is what they've already done before you arrived. The chain of entities, the commissioners they've already spoken to, the permits already fast-tracked, the timeline already set. Diane Colwell had handed me $41,000 in violations, but violations are the surface. I wanted the foundation. I also knew that the moment I identified myself, the structure would change. People would lawyer up, documents would move, hard drives would develop sudden and inexplicable errors. So I didn't. I poured a second cup of coffee, I opened my laptop, and I started at the beginning, the same way I always start, with the name on the incorporation papers and the question of who, exactly, benefits if this sale goes through. My father used to say, "Don't pull the fruit before it's ready. You'll ruin it and waste the season." He was talking about apples, but it applies. The 72-hour clock started at 9:14 a.m. on December 25th. I know the exact time because it was printed on the delivery stamp of the violation portfolio, and I am the kind of person who notices delivery stamps. That gave me until 9:14 a.m. on December 28th to either pay $41,000 in full, enter a compliance agreement on Ridgemont's terms, or face accelerated property lien proceedings. Every court in Buncombe County was closed until December 27th. That wasn't a coincidence. That was architecture. $41,000 is a number chosen with care. It's above what most families can wire transfer on short notice. It's below the threshold that triggers automatic federal review of debt collection practices. It sits in a range where most people's first instinct is to call a local attorney, who would then spend 2 days trying to understand an HOA charter that had been deliberately written to be difficult to parse, burning through the deadline before anyone filed a single motion. I'd seen this structure before, not with orchards, with waterfront properties in Georgia, with inherited farmland in the Mississippi Delta, with a family-owned cannery in coastal Maine that had been in the same family for 90 years before a manufactured code violation wiped it out in a single quarter. The method was the same. The timeline was the same. Only the geography changed. What was different here was personal. This wasn't a case file on my desk in Chicago. This was 38 acres of apple trees my grandfather had planted, that my father had tended through drought years and late frosts and 2 recessions, that still produced fruit every fall because the roots went deep enough to outlast hard seasons. This was the roadside stand my father built the year I turned 7. I remember the smell of cut lumber and the weight of the hammer he let me hold while he drove the first nail. This was the last thing he left, and someone had been watching it for 18 months, waiting for him to get sick enough that no one would be paying attention. 72 hours. Courts closed. $41,000 structured to be just out of reach. I looked at the calendar, then at the portfolio, then at the stack of letters from the bottom drawer. I had 2 days to understand the full shape of what had been built against this land. I'd worked faster with less. Ridgemont Community Standards Association was incorporated 14 months ago in Delaware. That was the first thing. HOAs don't incorporate in Delaware. Delaware incorporation is for entities that want liability protection, flexible governance structures, and minimal disclosure requirements. It's the preferred state for holding companies, shell entities, and anyone who needs to move assets without leaving a readable trail. A genuine neighborhood association incorporates in the state where the neighborhood exists. Always. The registered agent was a company called Blue Ridge Property Solutions, LLC. I ran Blue Ridge. Registered in North Carolina 8 months before Ridgemont. Single-member LLC. Owner listed as Caldwell Family Holdings, a Georgia-based entity with a registered address that matched a law firm in Savannah that specialized in, I checked, distressed property acquisition. I wrote that down. Then I wrote down the timeline. Caldwell Family Holdings existed before Blue Ridge. Blue Ridge existed before Ridgemont. Ridgemont existed before the first violation notice sent to my father. The violation notices began 4 months after my father's diagnosis. Someone had known he was sick before the paperwork started. Either they were watching very closely or they had a source inside the county health system. I noted both possibilities and kept moving. The violation portfolio itself was the second thing. Most fraudulent HOA documents are sloppy. Wrong statute citations, vague language, violations that don't map to any real ordinance. The people who build them are counting on the target not knowing enough to challenge the details. Diane's portfolio wasn't sloppy. It was precise. Time-stamped surveillance photographs dating back 18 months. Violation logs cross-referenced to actual North Carolina agricultural zoning statutes, correctly cited, correctly formatted. The debt structure referenced a legitimate legal mechanism called an assessment lien, which, under North Carolina law, can, under specific conditions, attach to real property. Someone with genuine legal expertise had built this document, not a paralegal. Not a county clerk with a grudge. Someone who understood property law well enough to construct something that would survive casual scrutiny. That told me the operation had resources. It also told me they'd done this before, because this level of precision doesn't come from a first attempt. I photographed every page of the portfolio with my phone. Then I pulled up the county property records and cross-referenced the assessment lien statute against Ridgemont's charter language. There was a gap. Small. Deliberately obscured by 3 paragraphs of procedural language clearly designed to make a reader's eyes slide past it. Ridgemont's charter granted emergency preservation authority only over properties within a defined community boundary. That boundary was described in Exhibit C of the charter. Exhibit C was missing from the portfolio Diane had handed me. I sat back. She'd handed me a document with a missing exhibit that defined the geographic limit of her own authority. Either she didn't know it was missing, which meant she hadn't read her own charter carefully, or she knew and was counting on me not to notice. Either way, she'd just shown me the edge of the foundation. I kept pulling. Diane came back the afternoon of December 26th. This time, she brought a man she introduced as her compliance coordinator. Younger, navy jacket. The practiced blankness of someone paid to stand in rooms and look like authority. She also brought a revised notice. Same $41,000, new language at the bottom about accelerated lien filing if I attempted to dispute the assessment through county channels before the deadline expired. Someone had told her I'd been pulling county records. I filed that away. I want to discuss Exhibit C, I said. She didn't miss a beat. Exhibit C is an internal governance document. It isn't required to be disclosed in a violation proceeding. Your charter says it defines the geographic boundary of Ridgemont's enforcement authority. If it's not disclosed, I have no way to verify this property falls within your jurisdiction. Mr. Merritt, She set the revised notice on the kitchen table with the flat finality of someone closing a transaction. I've been patient with your questions, but the deadline doesn't move because you have questions. The deadline moves when you pay or sign. The compliance coordinator hadn't said a word. He was looking at the kitchen wall just to the left of my shoulder, the particular gaze of a man listening hard while pretending not to. I had a choice in that moment. I could tell her what I knew. I could put my credentials on the table right then and watch the camel coat go very still. It would have been satisfying. It would have also been premature, because what I had was a structural anomaly and a chain of LLC registrations. What I needed was a complete record, the full wire transfer history, the county commissioners who'd been fast-tracking Ridgemont's permits, the developer waiting at the other end of a distressed sale. If I showed my hand now, the structure would fold inward. Documents would disappear. The developer would surface 3 months later under a different entity name and do this to someone else's land. My father's land mattered, but it wasn't the only land at risk. I understand the deadline, I said. I'd still like Exhibit C. She picked up her portfolio. You'll have our response to any further document requests through our legal representative. She paused at the kitchen door. I'd encourage you to think seriously about your position here. This property has significant development potential. The right buyer could make something of it. Holding on for sentimental reasons isn't always— Thank you for coming, I said. She left. I stood at the kitchen window and watched her car back down the driveway past the bare apple trees. The compliance coordinator turned once to look at the house before he got in. Just once. Like he was memorizing something. I wrote down his license plate. Then I called my partner in Chicago. My partner's name is Sandra Okafor. 15 years in financial crimes, 8 of them working rural property fraud specifically. She picks up on the second ring at any hour, which is a quality I have come to depend on more than I'd like to admit. I gave her the entity chain: Colwell Family Holdings, Blue Ridge Property Solutions, Ridgemont Community Standards Association, Delaware Incorporation, the missing Exhibit C, the timeline mapped against my father's diagnosis, the revised notice with the language blocking county dispute channels before the deadline. She was quiet for 4 seconds. Sandra is only quiet when something is worse than expected. That blocking language, she said, that's not standard HOA procedure. No. That's someone who knows exactly which window to close and when. Yes. Cole. A pause. How many properties in that county do you think Ridgemont has active violations against right now? I hadn't pulled that yet. I told her so. Pull it tonight and cross-reference against the county commissioner meeting minutes for the last 18 months. Development permit approvals, zoning variance requests, anything that touches agricultural land. I already had that tab open. The compliance coordinator, I said, navy jacket, didn't speak. Memorized the house on his way out. Send me the plate. I sent it while we were still on the call. She came back in under 3 minutes. Rental, corporate account, registered to a property management firm out of Charlotte. She read me the name. I wrote it down. It wasn't in the entity chain I'd already built, which meant there was at least one more layer I hadn't found yet. How close are you? She asked. Not close enough to move. Not yet. Another pause. The deadline is the 28th. I know. That's not a lot of time to build a complete record. I know that, too. I looked at the kitchen table, the portfolio, the letters from the bottom drawer, the notepad where I'd been mapping the entity structure in the particular shorthand I'd developed over 12 years of cases that started with one name and ended with 20. It'll be enough, I said. I wasn't entirely sure that was true. I worked through the night of the 26th, not frantically, methodically, the way you work when you know the clock is real but panic is the enemy of precision. First, the county property records. Ridgemont Community Standards Association had active violation proceedings against 11 properties in Buncombe County, all agricultural or mixed use, all inherited within the last 3 years, all with deadlines structured inside court closure windows, holidays, county maintenance days, a Tuesday in March that turned out to be a scheduled system migration for the county clerk's office. Whoever built this calendar knew the county's administrative schedule intimately. I photographed every record and uploaded them to a secure federal server Sandra had standing access to. Then I pulled the county commissioner meeting minutes Sandra had flagged, 18 months of them, every session that touched agricultural zoning or development permits. 2 commissioners appeared on every relevant vote. Both had approved Ridgemont-adjacent development permits with unusual speed, applications that normally took 4 to 6 months, clearing in under 3 weeks. I cross-referenced their campaign finance disclosures. Both had received contributions from a PAC registered in South Carolina. The PAC's treasurer was an attorney whose firm appeared in 3 of the LLC registration chains I'd already mapped. I added that to the record. Then I kept going. The Charlotte property management firm on the compliance coordinator's rental account connected to a development group that had acquired 6 distressed agricultural properties in western North Carolina over the past 2 years. All 6 had passed through some version of the same violation to lien to forced sale pipeline. All 6 had sold at prices between 18 and 23 cents on the assessed dollar. My father's land was assessed at just under $200,000. I understood now why someone had been watching it for 18 months. I documented everything in the format I'd use for a federal filing, time-stamped, source-cited, organized by entity and transaction date. Not because I was filing yet, because when the moment came to file, I needed the record to be clean enough that no defense attorney could find a seam in it. Around 3 a.m., I stepped outside onto the porch. The orchard was dark and cold and very still. 38 acres of bare trees, roots deeper than anyone walking this land for the first time would ever guess. I went back inside and kept working. The environmental inspector arrived Christmas afternoon. I hadn't finished my coffee. He drove a white pickup with a county seal on the door that I didn't recognize. Not Buncombe County, not any county I could place from the driveway. He had a clipboard, a hard hat he wasn't wearing, and a laminated credentials card on a lanyard he held out toward me with the practiced motion of someone who does this often enough that it's become automatic. Marcus Pryor, Environmental Compliance, Blue Ridge Regional Assessment Services. We've received a contamination report filed against this property. I'll need access to the eastern field and the area around the primary water runoff channel. $80,000 in remediation liability, another 72-hour window, conveniently timed so that both deadlines, Ridgemont's and this one, would expire before the courts reopened. I looked at his credentials card. Most people look at credentials the way they look at terms and conditions, long enough to feel like they've checked, not long enough to actually read. I read. Name, issuing agency, license number. I kept my face neutral. I'll need to see the original contamination report, I said. The filing agency, the sample chain of custody, and your state certification number. He blinked. Just once, but it was the wrong kind of blink, the kind that happens when a question lands somewhere a person wasn't expecting. The report was filed through the regional office. I don't carry the source documents on site. Then I'll need to verify through the state environmental database before I grant access. That's standard procedure for remediation assessments on agricultural land. He looked at me for a moment, recalibrating. Mr. Merritt, I understand this is a difficult time, but delay creates additional liability exposure for the property owner. My recommendation is we conduct the assessment today and address documentation through proper channels afterward. I said nothing. I just looked at him with the particular patience of someone who has heard better versions of that sentence from better prepared people. He shifted his weight. He had no idea I already knew his name from somewhere else entirely. Diane arrived 20 minutes after Marcus Pryor. I hadn't called her, which meant he had. She came with the compliance coordinator and a third person I hadn't seen before. Older man, sport coat, the particular confidence of someone accustomed to being the most important person in any room he enters. He didn't introduce himself. He stood slightly behind Diane's left shoulder and watched me the way investors watch a property they've already decided to acquire. "Mr. Merritt," Diane's voice had shed the last of its procedural courtesy. "You've now refused access to both a community standards assessment and an environmental compliance inspection. That's going to significantly complicate your position." "I haven't refused access to anything. I've requested documentation that any legitimate inspection requires." "Documentation requests are a delay tactic." She said it flatly, like she was correcting a child. "We've been more than patient with you, but I want to be very clear about something." She glanced back at the man in the sport coat, then returned to me with the settled certainty of someone who has just been reminded of the size of her backing. "People in your situation, inheriting distressed agricultural property, no local relationships, no legal resources, they don't win these fights. Not against an organized community association with county support. It isn't personal. It's just how these things work. People in your situation." I let that sit in the air between us for a moment. "Mr. Pryor's certification," I said. "Blue Ridge Regional Assessment Services. Can you tell me when that agency was registered with the state?" A flicker, gone fast, but there. "That's not relevant to—" "It's directly relevant to whether his inspection carries any legal weight. If the certifying agency isn't registered, the assessment is void. So is the liability notice attached to it." The man in the sport coat spoke for the first time. Low voice, measured. "Son, I've developed property in 6 counties across this state. I've dealt with a lot of people sitting exactly where you're sitting right now, thinking they had more options than they did." He paused. "They didn't, and neither do you." He said it kindly. That was the worst part, the genuine, practiced kindness of a man who had done this enough times that he no longer needed to perform cruelty. He simply stated outcomes. "I appreciate that perspective," I said. I looked at Marcus Pryor, who had not moved from the edge of the driveway. I already knew what I knew about him. I was deciding exactly when to use it. What's more dangerous, a person with real power or a person who has never once been told no? The Buncombe County Sheriff's deputy arrived at 4:47 p.m., not because anyone had called to report a crime, because Diane had filed an emergency obstruction complaint, property owner refusing lawful inspection access, potentially concealing environmental hazard. The deputy was young, thorough, and visibly uncomfortable with the situation he'd walked into. His name tag said Garrett. He had the careful politeness of someone who understood he was being used as a prop, but hadn't yet figured out how to decline the role. "Sir, I need to advise you that refusing access to a licensed environmental inspector can constitute obstruction under North Carolina General Statute 130A. If there's a contamination concern—" "Deputy Garrett," I kept my voice even. "I haven't refused access. I've requested that Mr. Pryor produce his state certification number and the original contamination report with chain of custody documentation. That's a standard requirement under the same statute you just cited, Section 130A-17, subsection C." Garrett paused, looked at his notepad, looked at Pryor. Pryor said nothing. "Mr. Pryor," Garrett said carefully, "do you have your certification documentation?" "It's on file with the regional office. Can you produce a copy today?" A beat too long. "I'd need to contact the office." Garrett wrote something down. The man in the sport coat, who still hadn't given me his name, took one step forward. "Deputy, this property owner has been obstructing legitimate community standards enforcement since December 25th. There are 2 active violation proceedings, an environmental assessment and a lien filing that's been properly noticed. At some point, obstruction has consequences." "Sir, I understand that." Garrett's voice stayed professional. "But I can't compel property access without verified documentation. That's the law." He turned back to me. "Mr. Merritt, I'd encourage you to cooperate with any legitimate inspection once documentation is confirmed. Is there anything else you need from me today?" "One thing," I said. "I'd like the complaint Diane Caldwell filed noted in the official record with timestamp, all of it. The specific claims, the parties present, the property address. Garrett looked at me for just a moment longer than necessary. Something shifted in his expression. Not suspicion exactly, more like the quiet recalibration of a careful person encountering something he hadn't expected. "I can do that," he said. Diane's jaw tightened almost imperceptibly. She'd brought the sheriff's deputy to apply pressure, to make me feel the weight of official presence, to give the man in the sport coat a visual confirmation that the system was on their side. Instead, she'd just created an official time-stamped record of everyone present, every claim made, and every piece of documentation that had or hadn't been produced. After Garrett left, the man in the sport coat looked at me with an expression that had shifted slightly from practiced kindness to something more careful. "You've done this before," he said, not a question. "Done what?" I said. He didn't answer. He walked back to his car. Diane lingered one moment longer. "December 28th, she said, 9 a.m. "I know," I said. I watched them leave. Then I went inside and called Sandra. "They brought a sheriff's deputy," I told her. "Good," she said immediately. "That means they're feeling pressure they shouldn't be feeling if this were routine. How's the record?" "Getting cleaner by the hour." "The warrant application?" "Ready to file the moment we have the full chain." "Then we're close." We were, but close wasn't there yet. Deputy Garrett came back the next morning, alone, no clipboard, no complaint to serve. He pulled up the driveway in his personal truck, a detail I noticed because the county seal was absent and the plates were civilian. He knocked twice, waited, and when I opened the door, he was holding 2 coffees from a gas station down the road. "Off the record," he said. "You want to talk?" I stepped aside and let him in. He sat at the kitchen table and looked at the notepad where I'd been mapping the entity structure. He didn't ask about it. He wrapped both hands around his coffee cup and stared at the middle distance for a moment, like a man organizing something he'd been carrying for a while. "Ridgemont," he said finally. "They've had active complaints in this county for 8 months. 3 families, all agricultural property, all inherited." He paused. "All resolved before anyone could get a filing in." "Resolved how?" "Sales, fast ones, below market." He looked at me directly for the first time. "The Alderman family, over on Route 9, 60 acres of peach trees, been in the family since 1962. They had a 72-hour window, same as you. They signed on hour 71. I said nothing. "I filed an inquiry report after the second one," Garrett said. "Sent it up to county supervision. Got a response that said Ridgemont was operating within its charter authority and the complaints didn't meet the threshold for further review." He turned his coffee cup slowly. "Both commissioners who signed off on that response are the same 2 who've been fast-tracking Ridgemont's development permits." He was telling me he'd tried. He was also telling me the system he worked inside had been compromised at the level above him, and he hadn't known where else to take it. "Mr. Merritt," he chose his words with the careful precision of a man who understands both what he knows and what he can prove. "I don't know exactly who you are. But the way you cited 130A-17 yesterday, the way you asked for the time-stamped record, that's not how a grieving son who just inherited a farm talks to a deputy." He paused. "So I figured if someone was going to do something about this, maybe they could use what I know." I looked at him for a moment. "You did the right thing coming here," I said. He nodded once, finished his coffee, stood up. "December 28th, he said at the door. "I'll be on shift." Have you ever watched someone do the right thing in a system that punished them for it, and say nothing because you knew their moment to matter was still coming? The evening of December 27th, Sandra called with news that wasn't good. The warrant application had hit a procedural snag in the federal district office. The duty magistrate reviewing it wanted additional documentation on the interstate wire transfer elements before she'd sign. Specifically, direct evidence connecting the Caldwell Family Holdings bank account to payments made to the 2 county commissioners. What we had was circumstantial, strong circumstantial, the kind that builds convictions, but not the clean transactional record a magistrate wants to see before authorizing a federal warrant on a Christmas week timeline. "How long?" I asked. "She wants the supplemental filing by 8 a.m. tomorrow. That gives us 1 hour before Diane's deadline." I did the math. Sandra was already working on pulling the bank records through a parallel financial intelligence request, but that channel had its own processing window. We needed one clean transaction, one wire transfer with both endpoints documented, and we didn't have it yet. "What about Pryor?" Sandra asked. Marcus Pryor. I'd been holding that card since Christmas afternoon.
I knew his name from a 2019 federal case file. Coastal Georgia waterfront development scheme, falsified contamination reports used to force distressed sales on inherited fishing properties. He'd been convicted, sentenced to 30 months, served 19, released on federal parole in August of 2021. His parole conditions included prohibition from any environmental assessment work and mandatory reporting of any employment in property-related industries. He was currently employed in property-related industries, conducting environmental assessments on federal parole. If I approached him now, tonight, before the deadline, I might be able to flip him fast enough to get the transaction records we needed before 8 a.m. But it was a risk. If he called Diane the moment I identified myself, she'd have time to move the money, destroy records. The developer in the sport coat had the resources to make a financial trail disappear quickly if he knew someone was pulling it. I stood at the kitchen window and looked at the driveway. In 9 hours, Diane Caldwell would arrive expecting a signature or a surrender. She had a developer ready. She had 2 commissioners on retainer. She had a system she'd run successfully against 3 other families in this county alone. What she didn't have was the thing she'd needed most from the beginning and never thought to check for. She didn't know who she was running it against. I thought about the Alderman family, 60 acres of peach trees, signed on hour 71. I thought about my father's letters in the bottom drawer, 18 months of escalating pressure against a man fighting cancer who didn't know the fight had 2 fronts. I picked up my phone and found Marcus Pryor's number. Some cards you hold, some cards you play at exactly the right moment. This was the right moment. Marcus Pryor opened his motel room door at 9:23 p.m. He was still dressed. People who are waiting for something bad to happen don't change into pajamas. He looked at me, standing in the parking lot light, and I watched the sequence move across his face. Recognition. Calculation, the particular stillness of a man trying to decide how much trouble he was already in. "Mr. Merritt, mind if I come in?" He stepped back. I came in. I didn't sit down, and neither did he. The room had the temporary, scrubbed quality of a place someone has been living in for several weeks without settling. 2 cardboard file boxes near the desk, a laptop, a printer still in its box, never opened. The kind of setup you build when you know you're moving on soon. I looked at the file boxes. He watched me look at them. "I reviewed a case file 2 years ago," I said. "Coastal Georgia, waterfront properties, falsified contamination reports used to manufacture remediation liability and force distressed sales." I let a moment pass. "Your name was in that file, Mr. Pryor, not as a witness." The color in his face changed in the way color changes when something a person has been dreading finally arrives and turns out to be exactly as bad as they feared. "I did my time," he said. His voice was steady. Credit to him for that. "You did. And then you were released on federal parole with specific conditions. No environmental assessment work. Mandatory reporting of property-related employment." I looked at him evenly. "You're currently conducting environmental assessments in connection with a property acquisition scheme that bears a structural resemblance to the Georgia operation. That's a parole violation. It's also federal impersonation because Blue Ridge Regional Assessment Services isn't registered with the state environmental agency. And depending on how the wire transfers are categorized, it may be fraud." He sat down on the edge of the bed, not dramatically, just because his legs made the decision before he did. "I needed work," he said quietly. "I know. I meant it. I'm not here to make your situation worse than it has to be. I'm here because I need one thing, and you're the person who has it." He looked up. "The payment records," I said.
how Colwell Family Holdings paid you, when and through which account, and any communications you have connecting that account to the 2 county commissioners. The file boxes. He'd looked at them twice since I walked in. If I give you that, he said, what happens to me? You call your parole officer tonight, voluntarily, before anyone else makes that call for you. You cooperate fully with a federal investigation. You testify if it goes to trial. I paused. What happens to you depends significantly on what you do in the next hour. He was quiet for a long moment. Then he stood up and opened the nearest file box. The payment records were in a manila folder near the top. 3 wire transfers. Colwell Family Holdings to a numbered account in South Carolina. That account to 2 separate LLCs, 1 registered to each commissioner. Clean, documented, time-stamped. I photographed every page. Sandra had her supplemental filing by 11:15 p.m. The magistrate signed the warrants at 7:52 a.m. Sandra called me 8 minutes later. We have them. I'm on the first flight out of O'Hare. Lands at 11:40. Diane's deadline was 9 a.m. There was a gap there, a real one. Sandra and the warrants wouldn't arrive until well after Diane did, and whatever Diane brought with her at 9 o'clock, I would be facing alone with credentials I still hadn't shown anyone in this county, except, implicitly, a deputy who'd come to my door with gas station coffee. At 8:47 a.m., a county vehicle pulled into the driveway. Not Garrett's personal truck, an official one. 2 men I hadn't seen before, county administrative staff, based on the lanyards, carrying a document case and a portable notary seal. Diane arrived 3 minutes later, the compliance coordinator, the man in the sport coat, and a 4th person, a woman in a gray suit carrying a leather portfolio, who introduced herself as Ridgemont's legal representative. They came prepared. They came with numbers. They came with the particular energy of people who have done this enough times to treat it as logistics. Diane didn't bother with pleasantries. Mr. Merritt, it's 9 o'clock. The assessment period has expired. Under Ridgemont's charter and North Carolina property lien statute, we are here to execute a voluntary compliance agreement, or, in its absence, file an accelerated lien attachment on this property effective today. She nodded toward the notary. If you sign the compliance agreement, the lien filing is suspended pending payment arrangement. If you don't, the lien attaches this morning and the property becomes encumbered. At that point, your options narrow considerably. The legal representative opened her portfolio and set the compliance agreement on the hood of my father's truck. 2 pages, signature line at the bottom. A pre-filled payment schedule that structured the $41,000 across 18 months at an interest rate that would bring the total to just under $64,000. The man in the sport coat stood slightly apart from the group, hands in his coat pockets, watching with the calm of someone watching a transaction he'd already mentally closed. I looked at the compliance agreement. I looked at the driveway full of people who had spent months building a machine designed to arrive at exactly this moment, exactly this configuration of pressure, at a time calculated to leave me no viable option. I thought about the Alderman family signing on hour 71. Sandra's flight was still in the air. The warrants existed but weren't here. Every person standing in this driveway believed with complete certainty that they had won. I picked up the compliance agreement. I read it slowly, all the way through, while they watched. Then I set it back down on the hood of my father's truck. "No," I said. Diane's expression didn't change. She'd expected this. She nodded to the legal representative. "Then we file," she said. The legal representative opened her laptop, and I heard the sound of gravel under tires at the end of the driveway. The car at the end of the driveway wasn't Sandra. It was a neighbor. Ruth Alderman, 71 years old, drove a green Ford pickup that had belonged to her late husband. She'd called me the evening of the 26th after Garrett mentioned my situation to her, carefully, off the record, the way careful people pass information when the official channels have been compromised. She pulled up and sat in the truck for a moment before getting out. She looked at the group assembled in the driveway the way people look at something they've seen before and hoped never to see again. She walked over and stood beside me without saying anything. I'd spent one evening with Ruth Alderman at her kitchen table, listening to her describe the 72 hours that ended with her signing away 60 acres of peach trees her family had tended since 1962. She hadn't cried telling it. She was past the crying part. She described it the way people describe a surgery, clinical, sequential, with the occasional pause where the emotion was too large for words and she simply waited until it passed. She'd signed because she was alone and frightened, and the machine had been designed to make alone and frightened people sign. She'd driven here this morning because she didn't want me to be alone. I thought about my father in October, the last night, the particular quiet of a room where someone is finishing. He hadn't talked much, but at one point, close to morning, he'd said, "The land doesn't need us to fight for it. It just needs us not to give it away." I hadn't understood exactly what he meant at the time. I understood now. He'd known something was wrong.
The letters in the bottom drawer. He'd kept every one of them, dated and ordered, the way a man keeps records when he suspects someday someone will need them. He hadn't had the tools to fight what was coming, but he'd preserved the evidence with the quiet, methodical care of someone who trusted that the right person would eventually find it. He'd left me everything I needed. He just hadn't known it was me he was leaving it for. Ruth stood beside me in the cold December morning, and we both looked at the group of people who had built a machine to take things from families like ours. Then I heard a second car at the end of the driveway. This one I recognized. Sandra drives a rental the same way she works a case. Fast, direct, no unnecessary movement. The black sedan came up the driveway and stopped. She got out, and behind her a second vehicle, unmarked, federal plates. I exhaled once. Some silences aren't emptiness. Some of them are everything that's been waiting for exactly the right moment. Sandra walked up the driveway with the warrants in a federal document sleeve and the particular calm of someone who has crossed a finish line before and knows exactly what the last few steps look like. The second vehicle, the unmarked federal sedan, parked behind her. Two agents I knew from the Chicago field office got out. They positioned themselves without drama, one at each side of the driveway, the way you position people when you want to make clear that the geometry of a situation has permanently changed. Deputy Garrett's county vehicle pulled in 30 seconds later. He'd been on shift. He'd been waiting. The driveway that had been arranged as a closing ceremony for a transaction Diane Caldwell had been building toward for 18 months now held a configuration of people and vehicles that told a completely different story. I watched the legal representative's laptop slowly close. I watched the compliance coordinator take one step back without appearing to realize he'd done it. I watched the man in the sport coat go very still in the particular way of someone rapidly reassessing how much personal exposure he was carrying. Diane looked at Sandra, then at the federal plates, then at me. For the first time since she'd appeared in this driveway on Christmas morning, she didn't say anything. I reached into my jacket and took out my credentials. FBI, Financial Crimes Division, Chicago Field Office. I held them open long enough for everyone present to read them clearly. Diane, her legal representative, the compliance coordinator, the man in the sport coat, the county notary who looked like he genuinely wished he'd called in sick. My name is Cole Merritt. I'm a special agent with the FBI Financial Crimes Division. I've been assigned to this case in both a personal and investigative capacity. I kept my voice level. The same voice I'd used every day since Christmas morning. Sandra Okafor is my partner. The documents she's carrying are federal warrants issued this morning by the duty magistrate for the Western District of North Carolina. Sandra stepped forward and presented the document sleeve to Diane's legal representative, who took it the way people accept things they already know contain bad news. The warrants cover financial records, communications, and electronic data associated with Ridgemont Community Standards Association, Blue Ridge Property Solutions, LLC, Caldwell Family Holdings, and related entities.
Sandra's voice had the clean precision of someone reading from a document they helped write. They also cover communications between those entities and two Buncombe County commissioners whose names appear in the wire transfer records we obtained last night. The legal representative opened the sleeve, read the first page. Her expression didn't change, but she stopped turning pages. Additionally, I said, Marcus Pryor has provided a voluntary statement and documentary evidence to federal investigators. That statement is now part of the case record. I looked at Diane. She was looking at my credentials, still open in my hand. She was reading them the way she'd watched me read her portfolio on Christmas morning, carefully, with the dawning comprehension of someone who has just understood that the document in front of them means something much larger than they'd assumed. You've been running this operation against at least 11 properties in this county, I said. Manufactured violation debt, structured deadlines inside court closure windows, wire transfers to two commissioners to fast-track development permits, a parolee conducting fraudulent environmental assessments, and a developer, I looked at the man in the sport coat for the first time since Sandra arrived, who has been acquiring distressed agricultural properties at 20 cents on the dollar across 6 counties. The man in the sport coat said nothing. His hands were still in his coat pockets. He was looking at a point somewhere beyond the apple trees with the focused blankness of someone listening very carefully to their own internal legal counsel. Diane, I closed my credentials. You told me on Christmas morning that I didn't understand the position I was in. I paused. I understood it exactly. I was waiting until you'd said enough and done enough that there was nothing left to interpret. Deputy Garrett moved to stand beside Sandra. He had the particular expression of a man who filed an inquiry report 8 months ago that went nowhere and is now watching it go somewhere. The legal representative looked up from the warrants. My client will need to speak with counsel before... Your client is welcome to speak with counsel, Sandra said. These warrants don't require her cooperation to execute. They require her presence. Ruth Alderman was standing at the edge of the driveway. She hadn't moved since Sandra arrived. She was watching Diane Colwell with the quiet, unflinching attention of a woman who signed a document on hour 71 and drove here this morning so that someone else wouldn't have to. Diane looked at Ruth. Something passed across her face, not remorse, not exactly, but the particular discomfort of having the human cost of a transaction made suddenly, undeniably visible. Then she looked at the warrants again. Then she looked at me. You were here the whole time, she said. It wasn't an accusation. It was the sound of a structure collapsing inward as someone finally understood its actual shape. I was here the whole time, I said. The agents from the Chicago field office moved forward. Sandra handled the paperwork with the efficiency of someone who had prepared it at 30,000 feet and landed ready to use it. Garrett coordinated with the county side. The legal representative made 3 phone calls in rapid succession, each one shorter than the last. The man in the sport coat was detained for questioning. He went without resistance, which told me his attorney had already told him exactly how much trouble he was in and what cooperation was worth. Diane Colwell was arrested on the 27th of December. Federal racketeering, wire fraud, conspiracy to commit property fraud across multiple counties. The compliance coordinator provided a voluntary statement before noon. Both commissioners were contacted by federal investigators before the end of the day. The lien filing that Diane's legal representative had been preparing to execute was never completed. The laptop stayed closed. The notary packed up his seal and drove away without notarizing anything. I stood in my father's driveway after they were gone and looked at 38 acres of bare apple trees standing patient and still in the December cold. Ruth Alderman stood beside me. What happens now? She said. Now it goes through the system, I said. The right way, the whole way. She nodded slowly. Your father would have liked to see that, she said. I didn't answer, but she was right. The federal case moved the way federal cases move, methodically, without drama, over the months that followed. Diane Colwell was indicted in February on 7 counts: federal racketeering, wire fraud across state lines, conspiracy to commit property fraud, and 3 counts of filing fraudulent liens. Her legal representative negotiated hard. It didn't help much. The record was too clean. Pryor's testimony was too detailed. The wire transfer documentation connected too many dots across too many counties for any single thread to be pulled without the whole structure coming down. She pled guilty in May. Sentencing was scheduled for August. The two county commissioners resigned in January, 2 days before the federal investigators formally requested their financial records through official channels. Resignation didn't help them either. Both were indicted in March. The man in the sport coat, his name was Gerald Foss, and he had indeed developed property in 6 counties across the state, cooperated with investigators in exchange for a reduced charge. His cooperation produced 4 additional cases in neighboring counties. The pipeline Ridgemont had been feeding turned out to be larger than even Sandra had estimated from the outside. The Alderman family's case went to civil litigation. 60 acres of peach trees sold under manufactured duress for 18 cents on the assessed dollar. The civil suit named Colwell Family Holdings, Blue Ridge Property Solutions, and Gerald Foss's development entity as co-defendants. Ruth Alderman's attorney was very good. I know because I found him. Merritt Orchards is still standing. In April, I drove up from Asheville with a local agricultural attorney and walked every acre with a county assessor to formally document the property's status, clear the fraudulent lien attempts from the title record, and establish a clean, legal baseline for the estate. The assessor was thorough. The apple trees were beginning to bud. Early because the winter had been mild, the way western North Carolina winters sometimes are when they choose to be generous. I'm not a farmer. I said that before, and it remains true. I don't know how to drive a tractor or read the weather by the feel of the morning air or judge a harvest by the weight of a single apple in my palm the way my father could. But I know how to keep something intact until the right person comes along to tend it. I've been talking to a young couple from Weaverville who have been leasing orchard land for 3 years and know apple trees the way my father knew them, with patience, with respect, with the understanding that the work is longer than any single season. We're still in conversation. My father used to say the best apple trees take the longest to grow. He meant it as an observation about horticulture, but he was also, I think, talking about everything worth having, the things that don't come fast, that survive hard seasons because the roots went down deep enough before the cold arrived. Justice works the same way. Slow, patient, worth every year of waiting. What's the one thing in your life worth staying quiet for until exactly the right moment to speak?